If you'd please stand for the invocation by Mr. English and the Pledge of Allegiance by Mr. Boswell.
Let us pray.
Dear Heavenly Father, we just want to thank you for this lovely day that you brought us. Also, Lord, we just ask that you be with us tonight as we conduct business with the community and the county. Also, Lord, we just ask that you just keep the folks in Texas and also Florida and Puerto Rico in your prayers, Lord, as we get off back on their feet. Lord, we also ask you to be with the military and law enforcement to keep us safe each and every day. I pray all these things in the precious and glorious name of Jesus. Amen.
Thank you, Mr. English and Mr. Boswell. If you will call the roll, Ms. Bailey.
Yes, Mr. Chairman. Mr. Apicella?
Here.
Ms. Panuch?
Here.
Mr. English?
Here.
Mr. Boswell?
Here.
Mr. Rhodes?
Here.
Chairman Cohen?
Here.
And myself, sir, we have a quorum.
Thank you, Ms. Bailey. At this point in time, we normally ask if there's any disqualifications for any items on the agenda.
Mr. Chairman, I'll be recusing myself from item 1 on the agenda.
All right, thank you, Mr. Boswell. And anyone else? Seeing none, we now go to a presentation by the Honorable Chris Rapp about our transportation. Good evening, sir.
Good evening. Good evening, Mr. Chairman, members of the Planning Commission. Christopher Rapp, Director of Public Works. I am pleased to provide the following road project update. The first project is the Poplar Road, Mountain View Road intersection improvement. This has been divided into 2 phases, and Novec is relocating at this time. Verizon should start their relocations in mid-October. We're working on bid documents to advertise, and we should put those documents out in November for construction firms to bid on them.
Mr. Chairman?
Yes, Mr. Rhodes.
Mr. Rapp, the Phase 2, is there an estimation of the cost of that?
Not at this time.
Okay,
no, sir.
thank you. Thank you, Mr. Chairman.
The first phase is going to address the sharp turn south of the intersection. The next project is the Brook Road Safety Improvement Project. The right-of-way acquisition is complete. Utilities have been relocated. We did put this out for a construction bid. The bids came in higher than the engineer's estimate, so we're going to re-advertise that. We have gotten approval from VDOT to lengthen the work hours. They were from 9 to 3 in the afternoon, and we're going to increase that. The contractors said that that was a big factor in increasing their costs, so that should bring the cost down. So we're going to rebid this project in December.
Chris, just for understanding, this is basically down towards the swamp area and then up towards the big hill, or is this
Correct.
closer up? Okay.
Correct.
Thank you.
You're welcome. The next project is ongoing, Garrisonville Road widening. I'm sure you've seen this project. The right-of-way acquisition is complete. Utilities have been relocated, substantially relocated. And just this week, we switched over from the new eastbound lanes were paved, and we switched over to the new eastbound lanes. So now we can start working on the median and the westbound lanes. On the eastbound lanes, we had a new curb and gutter. We graded the new lanes and we paved them. So that was an exciting milestone. That project is due to be completed October 2018. The intersection improvements at Route 1 and Courthouse, this actually also includes the Hope Road intersection, basically the Route 1 corridor. Right now, we're addressing VDOT comments on our construction plans and hope to go to right-of-way acquisition in the near future. Just some timelines. We're hoping to do start right-of-way in November of this year, and utility relocations October of 2018. and then start construction on this project in March of 2020, which is just slightly before the interchange project will be finishing up.
And just because I keep getting questions, people keep asking me about the horrible backups there with the lights in a rush hour, both AM and PM.
Right.
And then they just want, because over the years, there have been so many different discussions about what they're doing there. That's why I asked Mr. Harvey to check with you about, is there some way people can actually see what we're doing, or do we have to wait till VDOT comes back and then we'll be able to see?
No, we have graphics, and I've asked staff to put that on our website, and we can certainly share those with the Planning Commission, but, because we've had a public hearing and we generated graphics, so we'll be happy to share that. But just in general, some of the improvements are including turn lanes on Route 1, and then some turn lanes on Courthouse Road and Hope Road, so that we'll then be able to retime the signals, so you won't have the signal pattern you have now, which will make it much more efficient. We're also going to put in a median, so you'll eliminate some people turning left and holding up traffic, and it'll make it safer. We're also going to have some streetscape features such as sidewalk and landscaping.
Thank you.
You're welcome. The next project is Juggins Road. This is to improve Juggins Road for the new Moncure Elementary School project, but it's also to pave the remainder of the road down to the end of the public right-of-way. Our plans have been designed. VDOT's authorized proceeding with the right-of-way phase. Utility relocations are being designed, and we're doing some geotechnical work. The sidewalk project along Mine Road, that construction went really quickly. I think this is the first and last time I'll be providing an update on this, but we're proud of this project. It's 1,700 linear feet of sidewalk along Mine Road. It's heavily used by pedestrians. It helped close a gap between two existing sidewalks. In the wayfinding signs, we had another phase of the signs. There were 16 signs this time. They were for areas where VDOT was finishing up road projects, and those were fabricated, installed. A lot of the work was done getting approvals. The actual fabrication installation lasted several months, and this project is finished, and hopefully you've seen the new wayfinding signs. We've had several phases of the signs. Those are all locally administered projects. Some VDOT projects, the I-95 hot lanes, Southern Terminus. This is ongoing. It's currently ahead of schedule. You can see the dates in front of you. I do know it's ahead of schedule, but these are the official dates VDOT has given us for completion. Yes, sir. I've kind of heard off the record, but I don't really want to speculate. Yeah. And then the Rappahannock River crossing southbound I-95. This was approved for funding under Smart Scale. A citizen information meeting was held earlier this summer. There's a design build contract that will be awarded in early 2018. Construction starting later that year and then finishing up 2022. They did come out with a revised concept that they presented in June. And then the Hot Lane extension, there was a public hearing held Monday at Stafford High School. Basically, this would extend down to Route 17 and then tie into the Rappahannock River crossing southbound. And this project will complete about the same time as the other project. Courthouse Road, the widening and the interchange project. Shirley Construction in Dewberry was awarded this. It's design build. There's a temporary signal Colonial Forge High School, reduced speed limit. They should start clearing within the median on I-95 in a couple of weeks. And I had a question about this project. It's farther south, but I provided some slides for you. If you drive down 95 toward Richmond, between Ashland and Richmond, there's quite a bit of construction. They're doing a bridge replacement on Lewistown Road. And then they're farther south, they're trying to reduce the weaving and improve the merging as the left turn lanes on where you try to get onto 290, you get onto 295 if you're heading south. There's a lot of merging and it backs up, so they're trying to improve that, and also the merging going northbound as well. That concludes my presentation. Are there any questions?
Yes, Mr. English.
Is anything in the works for Telegraph Road? Do you know anything about that? Are they going to do
The-
any plans for that? I know.
Are you referring to the signal?
Yeah, they put in a temporary signal. Is that all they're going to do right now that you know of, or?
There was a smart scale project that was awarded to Stafford County, and there's an alternate design that we're working through with VDOT to get that approved. And once they approve that, we hope to move forward with that project. It would be improvements on Telegraph and Woodstock roads in Route 1.
The light is going to go near the crucifix? Is that correct, or is it going to
The
be?
temporary, right now, the temporary light's proposed to go at Telegraph Road. If the alternate design is approved, it would go in a new road where a new parcel's being developed.
Telegraph in Woodstock, is that where the light's going to go?
Telegraph in Route 1.
Oh, Telegraph, wrong.
Yeah.
So near the crucifix, is that correct, or is it right?
Yeah, it's still being evaluated by VDOT, but that's the plan.
Okay, thank you.
I spoke with VDOT today, and they're doing a warrant study that'll take up to 2 weeks, but we're actively engaged with VDOT on that temporary signal.
Okay, thank you.
Okay, any other questions for Mr. Rapp? Okay, I guess that ends it. Thank you, sir.
Thank you.
Appreciate it. All right, at this point in time, we'll go to our public comment section. If you're here to speak about any topic that is not the public hearing, which would be the item number 1 is the public hearing. So if you would like to speak about any other topic other than that, we invite you to come down to the podium. You have 3 minutes to speak. When you come up, we ask you to give us your name and your address, and then the light will go on, the green light will go on for you to start talking. When you hit 1 minute, the yellow light will go on, and then at the red light, we ask that you wrap up your comments. And hello, Ms. Callender.
Oh, I'm sorry, I jumped the gun.
No,
didn't
you
I?
were perfect. That's
Okay.
time management. We like that.
Okay, I'm Elaine Calendar of 622 Lancaster Street in Falmouth. I note that on your agenda, under committee reports, it mentions sign ordinance committee. I wasn't clear if you're actually giving a report on the sign ordinance tonight or not, or just listing the next meeting date. But I hope that you will comment on the sign ordinance, because the other day I saw something in the paper that the Board of Supervisors is talking about enforcing the new sign ordinance. The timing on this is, I believe, politically motivated, because it's just several weeks before the election, and you know that people put signs out along the highways and roadways of Stafford in promotion of their candidates. So I think the public needs to have a really clear understanding of their liability in putting a sign out. It could be in their front yard that may happen to be in the highway right-of-way. So this needs to be explained. And I do believe, and I want to state very clearly, I worked on signs and sign ordinance topics 25 years ago when I worked here at the county. And it has taken all these years to suddenly get people interested in cleaning up the size of the roads. So the timing of this is really, really interesting, and I hope it doesn't turn into a voter suppression issue where people don't even know there's an election because there are no campaign signs out. Thank you very much.
Thank you, Ms. Callender. And just so you know, we went through, I think it was an 8-month process where we went through the sign ordinance. We passed it, sent it to the supervisors, and they graciously sent it back to us. And our subcommittee's been working for, I think, about 5-6 months on this. So it's not a new thing. And so every meeting they come back, they tell us if there's an update, same way that the parking lot and green space landscaping one comes back and tells an update. So, all right, any other public members like to speak on anything other than the public hearing? Seeing that none, we will close the public comment section for the evening. And we have had a request by some members to go to closed session on an item or two, and so I ask Ms. Banuch.
Sure. Thank you, Mr. Chairman. I would like to motion pursuant to Virginia Code 2.2-3711A7. The commission desires to hold a closed meeting for consultation with legal counsel regarding 2 specific legal matters which require the provision of legal advice.
Okay, so Ms. Banuch has made the motion. Is there a second?
I second it.
Mr. English seconds. Any comments? All right, seeing none, we'll put it to a vote. And passes unanimously. We will return as soon as possible. Would you read something for us?
Sure. I would like to motion that the Stafford County Planning Commission on the 27th day of September 2017, that it be and hereby does certify that to the best of each member's knowledge, 1, only public business matters lawfully exempted from open meeting requirements under the Virginia Freedom of Information Act were discussed in the closed meeting to which this certification applies, and 2, only such public business matters as were identified in the motion by which the said closed meeting was convened were heard, discussed, or considered by the commission.
Thank you, Ms. Finucci. Is there a second? Second by Mr. Rhodes. Any comment? All right, we have to take a vote. The wonders of process. All right, Ms. Bailey? All right, and it passes unanimously. Mr. Boswell has, as we said earlier, was going to recuse himself from this topic, so that's why he's not with us this moment. Brings us to our public hearings section. Mr. Harvey.
Mr. Chairman, for item number 1, please recognize Susan Blackburn for the presentation.
Good evening, Ms. Blackburn.
Good evening, Mr. Chairman, Planning Commission members. This is, you are to consider the revocation of special use permit SUP 80-11, and the terminology for a special use permit was changed in 1994 for a conditional use permit, so that has been clarified. And the Board of Supervisors approved this special use permit on January 20th, 1981, pursuant to Resolution R81-68. And the special use permit was for used auto sales and service facilities located at 24 Derrick Lane on tax map parcel 21-44. And I have a picture of, do I have to do it? Okay, there we go. And 2144 is the property outlined in red. The property is Zone B2, hence the red outline, and which is Urban Commercial Zoning District, and it requires a cut for a motor vehicle sales facility. And the property has been owned by Mr. David Attai since 2003. The property was leased, and the tenant had been operating a motor vehicle sales business known as Premier Auto. In December of 2015 and September 2016, March 17, and May 17, 2017, staff received complaints about vehicle storage and employee parking associated with Premier Auto on 25 Derrick Lane, which is the property outlined in yellow, which is parcel number 30-1 and is across the street from this property. Each time the violations were verified by a site inspection, a notice was issued, And with each notice, 30 days were given to abate the violation. And on or before the 30th day, the vehicles would be removed from 30-1, the property across the street, and the motor vehicles then would return within the next several days. Violations starting in March were validated by taking pictures of the motor vehicles on the property and matching the vehicle identification numbers to the vehicles for sale on the Premier Auto website. We had listed various dates of inspections, which are in your packet, and it was the status of the inspections and the dates the notices were issued. We did not include the VIN numbers in this document. And over the past months, Premier has repeatedly violated the special use permit and county code by storing motor vehicles and parking employee vehicles across the road on the property that does not allow for such a use. And the most current photographs showed a violation as recently as June 20th. On September 9th, Mr. David Attai requested to schedule a site visit to discuss the violation and the corrective action. He had received a notice or the letter concerning the board hearing. And staff met with Mr. Attai and his attorney on site on September 14th. And staff observed that no cars were located on 25 Derrick Lane. Mr. Attai stated he had terminated the lease and the current auto dealer and with the current auto dealer, and that the business would be operated by himself. And the staff recommendation on this is with the assurance that the current auto dealer will be leaving the premises. Staff is optimistic that Mr. Attai will operate a business that complies with all the conditions of the special use permit and will not park automobiles for sale on the property that is not zoned for such a use. Therefore, since the violation has been corrected as of September 14th, staff recommends that the Planning Commission not recommend that the SUP be revoked. And if the violations of special use permit 80-11 conditions are cited in the future, enforcement action will be taken by the county. Do you have any questions?
Okay, any questions for Ms. Blackburn? Ms. Bailey?
I do have just a couple of questions, Ms. Blackburn. Who is the owner of the 24 Derrick Lane? I believe that's parcel 30-1.
The owner, according to the commissioner records, is SNPD Stafford Incorporated, and the address is 10104 Hackberry Court, Fredericksburg, Virginia.
Okay. Do we know whether or not the operators of the Eastern View, Premier Auto, I'm sorry, Premier Auto, if they have permission to park those automobiles over there?
Not to my knowledge, no.
Okay. Do we know if, who the owners are of did you say SP, what did you say that was again? SNPD. Do we know who those owners are?
No, but I could find that information out through the state records.
Okay. And the numerous violations that apparently occurred based on the information that you've provided, and you sent out letters. Who did you send the letters out to, the letters of the violation?
The notice of violations were sent to the property owner of 30-1, where the violation was occurring, and to the Premier Auto, who was the tenant on the property.
Okay. How do we know whether or not the tenant relays that information to the owner of the property?
That we do not know.
Okay. Did you send letters to the owner of the property, Mr. Attai?
We did send a notice for the Board of Supervisors hearing when this was first coming up. We sent a notice of this hearing, public hearing. We also we actually created a notice prior to in March that was addressed to his property.
Okay. I have no other questions. Thank you.
Mr. English?
Ms. Blackburn, you said you ran VIN numbers for the vehicles that were parked at 30-1, correct?
Yes, sir.
And who did those vehicles, when you ran the VIN numbers, who did it come back to?
They came back to Premier Auto.
So, and how many vehicles were there at the time? Did you remember how many vehicles you ran as far as the VIN numbers were concerned? A
No.
guesstimate.
20.
Okay, thank you.
Mr. Chairman?
Yes, Mr. Rhodes.
Just to confirm, on the original, when it was an SUP, on the original conditions that applied to, is condition number 7 still pertinent to the property carried forward throughout, which is that they can be revoked for violation of these conditions or for a violation of county code?
Yes, sir, to the best of my knowledge.
And when it says of county code, is there any limitation to that, or any county code?
I would have to ask
Just-
legal. I would think there would be no limitation.
I mean, that's why I read it, I'm just wanting to confirm my understanding of what that,
Ms. McLennan?
Commissioner Rhodes, based on the reading of the SUP, it seems to be pretty broad as to any county code violation.
okay, thank you. That's all I have. Thank you, Mr. Chairman.
All right, anyone else? Mr. Apicella?
Mr. Chairman, so tax map parcel 2144, that's owned by Mr. David Atai.
Yes, sir, according to the commissioner records.
Who was the proprietor at Premier Auto?
It was also a Mr. Atai,
So same last name.
same last name.
Is that a coincidence, or is there a family relationship?
To the best of my knowledge, and I'm sure the applicant can verify this, that it was his nephew.
Okay, thank you.
Just a couple of questions. Since we're dealing with coincidences, you were addressing the parcel where the cars were being stored, that staff rather ingeniously figured out was part of Premier through VINs. Did you check VINs on more than one occasion?
Yes,
Okay, and every occasion that there were cars sitting on a residential lot and cars that were being used for a business purpose, it was to Premier Auto?
yes.
Okay. And just out of curiosity, has anyone who is affiliated with 21-44 ever had any ownership, rentalship to 30-1 across the street?
Not to my knowledge.
Okay. And Mr. Harvey? Has,
Mr. Conrad,
Oh, you mean ever?
ever, yeah.
Oh.
Not right now, but ever
Oh,
in the history of the universe of the world, has the same person owned 21-44 and 30-1? He asked because he already knows the answer.
Yes, sir.
Thank you. Okay, thank you.
Can you tell us who that is?
Or was, is,
Was.
and was.
We had it listed as Atai Enterprises,
Okay,
according to the commissioner's record.
okay.
And do we know the person by name who owned that parcel? Or both at the same time?
Mr. Chairman, Mr. Apicella, I don't recall, but I think there was some maybe similarity in addresses of where that business was located compared to the owner of 2144.
Okay.
So just to clarify, at some point in time, somebody at a specific address associated with the name Atai owned both the site that Premier Auto sits on and the residential property where this house is located.
Yes, according to the commissioner's record.
And just to, again, get it in the public record, you're not allowed to park automobiles on residential property in the way that was occurring at that residential site.
Yes, sir. The zoning ordinance does not permit that use.
Thank you.
One quick question. Since you were in contact with the Commissioner of Revenue, was the property at 30-1 being taxed as residential or business when it was being used as a business?
We did not get confirmation from that, but I do not know why they would be taxing them as a business. All their records show that it's residential.
Okay, thank you. Ms. Fanucci?
I had one quick question. You had mentioned that you had sent several notices to the owner of 2144 regarding public hearings, et cetera, correct?
We had sent them, yes, for the Board of Supervisors hearing and for this hearing.
Okay, and what address did you send those to? And I'm assuming they were addressed to Mr. Atai?
They were addressed to Mr. David Atai at 25494 Hopton House Terrace, Chantilly, Virginia, which is the address in the commissioner's records.
So just for clarification, Ms. Blackburn, the notices of violation, which is different than the two that you just mentioned, were those notices sent to the owner, Mr. Atay?
No. They were sent to the property owner of 30-1 and the premier tenant of 2144.
Is there any particular reason why you did not send notices to Mr. Atay?
In the beginning of doing the investigation, there was no proof that the cars were owned by Premier. We were citing the property owner of 30-1 for having cars parked on the property without appropriate zoning approval.
Okay. So when Mr. Atay did receive the notice regarding the Board of Supervisors meeting, and you said that he responded promptly?
Yes.
Okay, thank you.
Mr. Chairman?
Yes.
I do have a
John.
follow-up question, piece of new information. So you got the address for Mr. David Attai from the Commissioner of Revenue's
Yes.
office. So Mr. Attai obviously has to pay taxes on that parcel. How is the commissioner collecting taxes, property taxes, if they don't have the right address? Presumably, if that's the address of record for Mr. Attai, who owns this parcel,
Yes.
how are we collecting taxes? How are we sending a notice out to Mr. Attai to get his taxes if this is the incorrect address? When you get your property tax
Yes,
bill, it's
yes,
sent to
I
you. I'm
understand.
trying to understand, how are they paying their taxes? You get a notice every year what
Yes,
your tax bill
yes.
is. Am I losing you?
Yes.
And probably that'd be one for the applicant and his,
I'm just trying to understand how the Commissioner of Revenue could have the wrong address and how the taxes are getting paid if there's some disconnect between the address that they have in their records and Mr. Attai's actual address.
Mr. Cohen, or excuse me, Mr. Chairman, Mr. Apicella, I think the issue's getting a little bit confused in that the property owner has their address in the Commissioner of Revenue's records, but notice was sent to the operator of the
Yes.
site on the parcel 2144 at the address of, I believe, of 24 Derrick Lane.
Yes.
So the notices went to 24 Derrick Lane rather than going to Chantilly.
Right, but I see at least one notice of violation dated March 9th to David Muhammad Attai at 25494 Hopton House Terrace, Chantilly, Virginia, 20152-5817. So at least one notice was sent to that address, and you're telling me that that address is what the Commissioner of Revenue has in their
Yes.
system, and I'm trying to understand how they pay their taxes if they're not getting a tax bill. I'll just leave it out there, and we'll follow up with the applicant. Thanks.
all right. No other questions for Ms. Blackburn? Thank you. Mr. Lemming, I believe you're representing the property owner?
Good evening, Mr. Chairman and members of the commission. I'm Clark Lemming. I'm here on behalf of the owner. The owner is Mr. David Attai. He's owned the parcel where Premier has been located since 2003. In 2014, he entered into a lease with Premier Auto, and it is owned, to my best knowledge, it is owned by his nephew, who is another Mr. Attai. Now, the nephew, Mr. Attai, owned Premier Auto and rented the premises for approximately 4 years. His lease has been terminated. Now, back to the notice issues. The Commissioner of
Well,
Revenue. Yes.
Terminated, so.
Yes.
When I drove by today and I saw cars on the lot, who's selling the cars on the lot?
He has until September 30th to remove all of his inventory from the property.
The nephew still can operate even though the lease has been
He
terminated,
cannot sell a car.
so he just can store them there.
Yeah, he's got till the end of the month to move them out. I think you have my letter to him attached to the
Okay.
material that you have, so
Thank you.
he's gone. Now, with regard to the addresses, the Commissioner of Revenue, I think what Mr. Harvey is telling you, they have the correct address for Mr. David Attai. That's the Chantilly address. The notices all of the notices. There was a 2015 notice of violation, there was a 2016 notice of violation. They went to Premier Auto. There was no effort to send those notices of violation to Mr. David Attai, the owner of the property, notwithstanding his being the owner as shown on the Stafford County tax records. No effort to send those notices of violations. In 2017, there was a notice of violation prepared that bears Mr. Attai's address. If you'll notice, on that letter, it has the same certified mail number that the letter that went to Premier Auto has. Now, Mr. Attai did not receive at his address in Chantilly any notice of violation ever. We tracked that, and we've provided this information to Ms. Blackburn. We tracked that through postal tracking. That particular letter with that certified number was delivered to the Stafford address. It never even reached the Northern Virginia distribution center. So, don't know what the explanation is. Did they put two letters in one envelope? Don't know. But the Postal Service indicates that it never made it to Chantilly. Now, Mr. David Attai's first notice of any of this, and yes, this is his nephew. The nephew lives in Prince William County, near another member of the family. Mr. David Attai, lives in Chantilly with his family. He's not been to Stafford since the lease has been in place. He's had no indication that there was a problem here on the premises. He does not own or have any interest in property across the street. The only parcel that he owns in Stafford County is the parcel where Premier Auto has been operating. Now, he did receive by regular mail Mr. Harvey's letter notifying him that the Board of Supervisors was going to consider a resolution sending this back for your consideration and then back to the Board of Supervisors. The consideration being revocation of the SUP, which belongs to the owner. Now, your ordinance requires that the county notify the owner of the property of a notice of violation. That didn't happen here. It has been my position, is still my position, that the county had no authority to do anything here because the notice of violation was never sent to the owner of the property, and not through any fault of the owner of the property. But that's where that stands. Now, that's Mr. Attai's legal position. When he did receive notice of what the Board of Supervisors was going to consider, he got right in touch with Mrs. Blackburn. She alerted him what was going on. He came to see me. We started investigating it. We set a meeting up. I went over and looked at the property. We set a meeting up with Ms. Blackburn, I believe on the 14th of September. We set the meeting up on September the 9th. The board acted on September the 5th. He received the letter from Mr. Harvey on September the 1st. So on September the 14th, the violations had been rectified. The violations being the cars parked across the street on the R1 property and a fence that had been erected. Those were the violations that the notices were sent out to. Now, the lease was terminated on September the 12th, and the younger Mr. Attai, the nephew, was given until September 30th to completely relocate all of his inventory. He relocated all of his inventory across the street by September the 14th. So that's what Mr. David Attai did when he learned of what was going on. Now, we don't contest. We don't quibble one bit with what the nephew was doing. It's pretty reprehensible. And if the owner had known about it in 2015 or 2016, it would have been corrected at that time. If he had known about it in 2017, back in March, before any of this went to the Board of Supervisors, it would have been corrected. And I think the evidence of that is what he did when he did learn of what was going on. So no patience for what the nephew has been up to. In addition, I don't blame the neighbors for being upset about it. You know, in addition to the zoning violations, I don't think, it is my understanding, that the owners of Premier Auto have not been very good neighbors. And there have been issues between some of the workers there and some of the neighbors. There have been issues of parking, unloading cars on Derrick. What Mr. David Attai has done, and Mr. David Attai could not be here this evening. He will be at the board hearing. But this young man here, Mr. Prosser, has worked for Mr. David Attai for 6 years. And he will be on site all the time. Mr. David Attai is going to operate whatever business comes out of the ashes here. There will be no cars driven up and down Derrick Lane. I understand that there had been some test driving up and down Derrick Lane. That is not going to happen. There's not going to be any truck parked on Derrick Lane unloading. They'll do that on the lot. Mr. David Attai has actually been around to some of the neighbors to try and talk with them and explain what he has done and what he's going to do.
Mr. Lemon?
So, yes.
Yes,
ma'am.
could you repeat what you just said about the unloading of vehicles?
Yes, it was my understanding that on occasion, trucks, carrying cars, carrier trucks would stop on Derrick Lane, blocking traffic to unload their vehicles. That's not something that can happen.
Right, so where would they unload? Because there's not
They would
enough
have to
room
pull
on that
onto, they would
site.
have to back onto the property. There are
property?
travel ways on the property.
Which property?
Oh, the used car property. Yeah, the one up front.
Okay, because there's
yeah.
not a lot of room on that.
No, there's not. It's a tight fit. Now, keep in mind, though, that that's a pretty unusual circumstance because these are not, they're not delivering new cars here. Most of these cars are purchased locally, mainly at the Fredericksburg Auto Auction, and are driven actually to the premises. So it's just I heard that had happened from some of the neighbors. And so that's not going to happen is the point, I think. Not a lot of reason for it to happen by virtue of the business. It's not something that should be happening anyway. So I think that, and I'm a little confused as to my status here. I've been called the applicant or the representative of the applicant a couple times, so that means I get to keep talking, right? I think the important point, I thought I was just going to have 3 minutes. The important point here, I think, is that the owner of the property has stepped in and done what should have been done a long time ago. And the owner did not have legal notice of the notices of violation. There's a lot of rights that run through that. Notice is one of the most fundamental aspects of due process. There's an appeal period that runs with all of these notices. All of that is out the window because the notices weren't sent to him. So no confusion on the records of the Commissioner of Revenue. His address is there, has been there, and he does pay his tax bill because that does come to him at his address in Chantilly. And that's where the notices of violation should have gone. So I'll be happy to answer any questions. That's about all I can say except to tell you that Mr. Attai would apologize to the neighbors for what's happened. I mean, he's not at all had, this is a major family rift at this point. I mean, not only has the nephew created a problem for him, it's his special use permit, but the nephew has crossed another line, inter-family line, by causing these problems. So major rift within the family here. But he's done all he can, and he's sorry for what happened, and assures the neighbors and the residents of Derrick Lane and the commission that this is not going to happen again.
Okay.
Mr. Lemming?
Ms. Bailey first, and then Mr. Rhodes.
I'm
Yes.
sorry.
No, that's fine.
Yes, ma'am.
Has Mr. Attai spoken to any of the homeowners
Yeah,
on that street?
Did you go and visit? Who went to the neighbors?
Okay, so
This
not
is-
actually,
Yeah, but
Yeah.
did you know if David actually visited one, or did he designate you to do so?
Okay.
This young man who's going to be the person on site who works for Mr. Attai is the one that went to the neighbors. So,
all right, Mr. Rhodes?
Mr. Lemon, can you confirm, is Mr. Attai have any association with the LLC that owns the property across the street where the vehicles were being parked?
not that I know of. I don't have any, he's indicated that the only property that he has an interest in here is the property where the car dealership is.
Thank you.
So, there's more than one Attai. So, now it's interesting, the property across the street, I mean, we tracked those notices of violations too. We tracked the postal, using the postal tracking service, and they all went somewhere in Fredericksburg. But, and we actually looked up that corporate entity. We didn't come across any Attais, but those letters went somewhere else, and whoever the property owner is, I assume the county tax records can clarify that.
Okay, Ms. Manuch, did you?
Yeah, can you remind me, Mr. Lemming, what date did Premier Auto take over the lease of that property?
2014.
2014. And to you or your client's knowledge, were there ever any employees at Premier Auto with the name of David?
Not that I know of. I mean, do you know?
So
And
I
it's
was just,
It's certainly possible, but Mr. David Attai did not work there. He has a number of other businesses to tend to.
and so he's never worked on the property?
No, not that I know of, no.
Because
We
I was
wouldn't have
just
any
on
reason
Yelp
to.
reviewing, and it said that there was a complaint against a Mr. David that kept texting that worked on the property, that was the owner. So,
Mr. Lemming, if you could aim a little bit more for the microphone.
I'll aim for the
Thank you.
microphone. What was the date of that? I don't know
it
what
was
you're
that in
referring to.
2015. That it
Yeah.
was, there was a David, the person that was writing the Yelp review
Mm-hmm.
was, calling the dealership about a car, and that they kept getting phone calls and harassing text messages from a Mr. David at Premier Auto.
I don't have any knowledge that a Mr. David Attai had anything to do with the business whatsoever, including working there in 2015. Now, Mr. David Attai did run the business, another business, not Premier Auto. And Premier Auto is what's there now. Prior to 2014, Mr. David Attai was the one that operated the business on the property.
Okay, yeah,
But
this was.
that changed in 2014.
This was in 2015, I believe it was April of 2015, so it would just, obviously, actually, excuse me, June 1st of 2015 would contradict the fact that David had not known about violations because he was on the property and would have seen the way that it was being operated.
I don't know what you're looking at or what the source of information was, or, what you're saying is news to me.
Okay.
Mr. Apicella?
Mr. Chairman, just kind of a follow-up question. At any point in time, to your knowledge, did Mr. David Attai own both the parcel that Premier Auto sits on and also the adjacent parcel at 25 Derrick Lane, either directly or through some corporate entity?
Not that I know of, no, sir.
When you talk that way, it's not
Trying to be polite.
I
Not
know.
that I know of.
Thank you.
Okay. I just have a few questions. If I could, you stated that once David Attai was informed of these violations, he expediently dealt with the fence. Okay, how did he know did he take down the fence himself? I mean, pay for it to be taken down?
Do we know who took down the fence?
Okay.
Don't know what the answer is, except the fence was gone. He may have told his nephew to get the fence down.
Okay.
I don't know who actually physically removed it.
Okay.
I do
But
assume-
once he was, but he had the authority to make something happen across the street.
Well, I think the nephew is the one that put the fence up.
Okay.
So yes, I think he could direct the person that put the fence up to take the fence down.
Okay. Just a question, and I forget the gentleman's name, that in the red there, you said he's going to be taking over the day-to-day operation?
He'll be on site
On site?
all the time.
Did he
yes,
ever
sir.
work for Premier Auto in any way, shape, or form?
Did you ever work for?
Yes, sir. No, sir. Okay. And then I'm just curious, so when you say that the cars will be removed, and then Mr. Attai is going to bring over and be doing his own thing, these will not be the same automobiles?
No, they don't belong to Mr. Attai. They belong to Premier Auto.
Okay.
So those cars will all be removed. They'll go wherever else young Mr. Attai takes them. So
Okay.
anything that Mr. David Attai does would involve completely new inventory.
With new VIN numbers?
Yes,
Okay.
yes.
Mr. Lemon, can you just repeat his name? I think we, oh, sorry, can you just repeat his name? I don't think we remember.
Whose name?
The gentleman in the red.
It is Ryan Prosser.
Okay.
Okay. For some reason, I was thinking Preston. Did you want to ask?
Yeah, Mr. Lemon, you said Ryan, he said he went to all the neighbors on Derrick Lane. Did you? And how many did you go to?
If you'll come up and talk,
on
please.
I told him he wouldn't have to do this. Okay.
See, you shouldn't make promises.
Hello.
Hello?
So I made an effort to go to.
Introduce yourself. Say what your name is.
I'm sorry. My name is Ryan Prosser. I made
Where
an.
do you live?
I live in Stafford, Virginia.
The address, that's
40
usually our procedure.
I'm sorry, 46 Acadia Street, Stafford, Virginia.
Thank you.
So I did make an effort to go to all the neighbors on Derrick Lane, just to offer our position with what's going on and offer also a solution to the problems that we've been alerted are going on.
How many did you physically speak to?
I spoke to a Miss Darlene that lives on Derrick Lane, and she introduced me to another lady that visited our home when I was there one day.
All right, and when was this?
That was yesterday.
So you only visited two? You only made
I
contact
made
with two?
contact with Darlene on Sunday as well as yesterday.
Okay, so you've only talked to two, and I don't know how many people live on that lane. Okay.
Correct.
You didn't leave some sort of calling card, say nothing like that?
Actually, yesterday I left a letter in every mailbox on Derrick Lane explaining a general explanation as to what we're looking to do moving forward.
Okay. All right, thank you.
Thank you. And I'm sure Mr. Lemming will make you aware of the fact you can't put it in the mailbox in the future.
I didn't know what he was doing, but.
Yeah, I know, really, yeah.
Don't do that.
Okay.
All right, one question though, you indicated to me that you'd worked for Mr. David Attai for 6 years.
Correct.
Can you tell me where that was?
Yes, I run a dealership for Mr. Attai in Prince William County, just the day-to-day operation of that dealership. So we will be hopefully operating out of Derrick Lane as well. So there will be different vehicles, different employees, different everything.
And you heard what they said about the VIN numbers. I don't want to see any of the VIN numbers that are there now.
Correct. So we have our own vehicles, we have our own means to buy vehicles, and we have no connection to Premier or their inventory or their employees going forward.
What's the name of
Okay.
Mr. David Attai's
Again,
operation?
Mr. Lemming, if you'll move a little bit closer to the mic
What's the name of
for our
Mr. David
fans.
Attai's operation in Prince William?
Lease Return Center.
Could you, a little louder? Lease?
Return Center.
Okay. Well, what's that mean? As somebody who doesn't sell cars, does it mean I didn't pay my lease on the car and they take it away from me, or what's that mean?
No, sir. If you were to lease a vehicle, after turning that vehicle into the manufacturer, we would then purchase from the manufacturer and resell it.
Okay. Thank you.
Yes, sir.
Go ahead,
Sir.
Mr. Apicella.
So you're going to be on site on a day-to-day basis?
Correct.
So if neighbors have any issues or concerns, you're the person they should come and see?
Absolutely. I live right down the street, so I'll be there all week, every day.
Okay, thanks.
Yes, sir.
Okay. Mr. Rhodes.
Mr. Lemming, just to confirm, did you say that Mr. Attai was operating there before he leased the property to his nephew?
Yes.
So the Eastern Autos, or whatever you referred to that as,
Do you know for
was
sure
his operation?
Eastern Auto, was that Mr. David Attai's, the name he called it, or was that even between? Prior to? Okay,
So it was one in between?
Right. 2003 is when he purchased the property. What I don't know is whether he continued to lease it to
Okay,
the
that's
operator
fair.
of Eastern and then took over it and operated.
I was only generally curious. I noticed from one of the neighbors, one of their letters, they reference good relationships when Eastern was there and then bad relationships with Premier. So thank you.
I think one of the letters did indicate that it's been over the past 3 years that there really been the problems, and Mr. David Attai would have been responsible prior to that point in time.
I just have one last question. Does Mr. Attai have other car dealerships that are spots where he leases to other people to do this type of activity? Or was this just a one-time, thing?
Do you know that? Does he have other dealerships that he leases to anybody else?
Or spots? I'm
Or
not
or
saying
or
dealership because I would
locations.
infer that, unless it was his dealership.
Not anything up north?
Okay.
Okay.
All right, thank you. All right, there are no more questions for Mr. Lemming, so thank you very much, and thank you, Mr. Presser.
Yes,
We now open up the public hearing segment of our meeting. At this point, people who wish to speak on this topic are encouraged to come down and come up to the microphone. You have 3 minutes to speak. When the green light comes on, please state your name and your address for the record. Then you have 3 minutes to speak. When you see the yellow light, that means you have 1 minute left. And when the red light hits, it's time for you to wrap up your comments. So, welcome down.
Hello? Is the green light on?
Nope, after you speak. Yep.
Okay, my name is Darlene Pack. I live at 35 Derrick Lane, Stafford, Virginia, and I am here to support the revocation of the special use permit 80-11. Over the past 3 years, Derrick Lane has had different dealerships on this lot. Previous dealerships have made adjustments to minimize impact to the neighborhood, with the exception of this last one, Premier Auto. By ignoring the inspectors and issues that Derrick Lane residents have had, this dealership blatantly ignored the codes and regulations of operating auto sales business in Stafford. Use of residential lot across the street for parking, fixing, detail, and selling cars time and time again have ignored the notice of violations. And of course, I provided all these attachments to my speech. Let's see, at various times, the truck carriers have been in the middle of Route 1, the right-hand side southbound, the right-hand side northbound, and on Derrick Lane. There is no room for any delivery of unloading cars on that lot. It is too small. Its customers have used the Premier Autos has used Derrick Lane as an extension of their lot, parking in the middle of the street, leaving their car doors open, not even moving when we had mentioned that that is not a place of business. You're in a street, and they still stay there. And Premier Autos' response was that we have no control over what our customers do. Over the years, I've been a recipient of obscene gestures. I've attached those. And on August 31st, there was a fence being constructed. We called to inform the county. The inspector came out, told them to stop. As soon as they left, they went ahead and finished the fence, and that's another blatant disregard for the codes and regulations. I do not believe this is the type of business that Stafford County needs. The county allowing this to go on as long as it did not protect the residents, nor does it reflect well on Stafford County. And I do not agree with Harvey's decision recommendation. And I am sorry, but after 3 years of all this happening, Mr. Attai being a businessman, not knowing what was going on in that whole 3 years. Thank you.
Thank you, Ms. Pack. Anyone else wish to speak? Good evening.
Good evening. My name is Rayanne L'Italian. I live at 29 Derrick Lane, right next door to the property that has been abused. My husband wrote a letter. He's out of town tonight, so you each have the letter. I don't really need to tell you any more than what the letter already says and what's been discussed tonight, but just that, you know, we want y'all to know that we're not happy with the way things have gone. All right?
Okay.
Thank you.
Thank you, Ms. L'Italia. All right.
Good evening.
Good evening.
My name is Sylvie Pendleton. I'm at 57 Derrick Lane. Basically, I don't need to repeat everything that the lawyer has said and my neighbors and whatnot when it comes to the problems that we've had. But I guess my question would be, for what's going on now, is like, what kind of insurance do we have from you guys that whatever decision you guys make, whether you take away their permit or keep it with the new gentleman here running it, that things are going to be okay? Or are we going to start at zero again, 6 months from now with them parking and doing whatever? Everybody keeps saying there's no relation, but they put up a fence on the property. They could have came to my house and put up a fence. And, the bottom line is I find that hard to believe that there was no correlation between the two properties, somehow relation or friends or whatever the case may be, or arrangements. So what I bring to you all is, what kind of assurance as homeowners and residents of Stafford County do we have that we're not going to have any problems with this gentleman here complaining and then, being, like Ms. Darlene Pack mentioned, hand gestures and intimidation when we pull in out of our street. I have young drivers in my family. I don't want them to feel like they can't come home from work because of, new drivers and those kinds of things. So, I would like to at least know what will happen at that point if something else was to, start up again. Do we have to start all over, or what the case may be? I've been there the longest. I've been there 22 years on Derrick Lane. I'm the longest resident, other than the Elkins, which are not here this evening, but never had these problems until the last 4 years, and very rude and very, I can't even express how difficult it's been with the way that they've treated us and disrespect and everything else. And I don't think anybody in our neighborhood ever did anything to be disrespectful for them, even despite the fact that they were disrespectful for us. So, again, you're already aware of all the situations and the problems and the parking and the blocking of the roads. So hopefully you guys will vote accordingly. Thank you.
Thank you, Ms. Pendleton. Anyone else?
Hi, good evening. I'm Sharon McPherson. I live at 65 Derrick Lane, so good evening, Chairman, and thank you, gentlemen and ladies, for listening to us tonight. I think our issue is that we are not anti-business. We are good neighbor people. And we've been in a situation where we've had people that are taking advantage of our goodwill and the goodwill of the county, taking advantage of the loopholes and of the lack of communication or the possible, let's put it politely, the possible misunderstanding of who the actual owner of a property is because of maybe shared last names. What we're looking for is a resolution for our situation where we'd like a good business there. We want a good relationship. We understand they're going to be there. However, we have people that have been taking advantage of the loopholes and the goodwill of the county by violating ordinances. And that puts other businesses that are in the county that are operating in good faith and following the ordinances that the county has in place for fair play, not only zoning to protect the residents and the safety of the residents, but zoning to protect the business interests and how businesses have a level playing field when they are out there. We are dealing with a business for whatever reason, a business that has not been playing on a level playing field and has been taking advantage not only of us, but of you. Some of the things that have not been mentioned, and I'd like to bring it a little bit more into the record, our street, when you are coming north on Route 1 and you turn onto Derrick Lane, it's like a 125-degree angle. So if you have anyone that have a car from the dealership sticking out into the street, if you have a car being unloaded from a truck carrier, if you have a car from a customer parked even a half a car length, 2 car lengths from the intersection of Derrick Lane and Route 1, then you have a safety issue. And again, we have young children, we have young drivers on that street, and that puts all of us at risk. I have to admit, I've lived there for years now, and I'm nervous every time I'm coming north. I'm slowing down really, really slowly, and I've got people behind me honking their horns because I want to make sure that when I'm taking that right turn, there's not going to be someone sitting there parked in my right-of-way driving on a public street to be safe. And I have to admit, there are a couple times I'm coming very close to people running into the back of me. So it is a safety issue as well. We appreciate your time. We hope that you'll make the right decision and understand our concerns.
Thank you, Ms. McPherson. Anyone else?
Good evening, members of the Stafford County Planning Commission. My name is Sharon Goodchild, and I live at 45 Derrick Lane in Stafford, Virginia. After 3 years of complaints filed, followed with violation warnings and citations by Stafford County Zoning Enforcement, Premier Auto and Mr. David Attai stopped disregarding the county and came into full compliance. This was only after the Board of Supervisors unanimously voted on September 5th, 2017, to consider revoking his SUP. Mr. Attai did not terminate the lease for his bad tenant, Premier Auto, until September 12th, 2017. Instead, the violations escalated through 2016 as Premier Auto's operation bled onto the adjacent lot until September 14th, 2017. This and other activities were documented by our community in the form of calls, time date stamped photos, and attached to emails sent to Mr. Harvey and Mr. Milday. Reports were made to the Stafford Police Department regarding harassment, the unloading of the tractor trailer carriers on US Route 1. This is a violation of Municipal Code Section 28-104, which forbids any loading or unloading on any public right-of-way. To my mind, this is an egregious disregard for safety, combined with multiple temporary compliances, indicates an absentee owner hoping the community would stop pressing the issue rather than terminating Premier Auto's lease months ago. Mr. Ryan Prosner, who I've met, I am the other party, assured he will operate only on parcel 21-44 in accordance with county ordinances. Mr. Harvey and his staff may be optimistic that Mr. Attai will continue to comply. Our community's experience with this owner does not leave me feeling such optimism. I ask that the Planning Commission consider revoking an SUP issued for a tiny pie-shaped lot when Derrick Lane was a dirt and gravel road with 4 homes and significantly less traffic congestion on US Route 1, and forward this action to the Board of Supervisors for public hearing and final consideration. Thank you so much for your time.
Thank you, Ms. Goodchild. Yes, sir.
Good evening. I'm Bob Goodchild. I live at 45 Derrick Lane. There's only one thing I want to bring to your attention or call to your attention tonight. It was initially brought up earlier in the conversation about SUP 80-11. That SUP was requested by Calvin R. Brooks, who submitted it, and it was approved by the Board of Supervisors at that time with conditions. The number one condition is that the permit is for Calvin H. Brooks and is not transferable. So I believe this SUP should already be dead. And the business, no, I'm not against the business, but they need to go to the supervisors and they need to request a CUP to use the facility under the current modern rules and regulations. Thank you.
Thank you, Ms. Goodchild. All right, anyone else wishing to speak? Seeing none, I will close the public hearing. Normally, when there's an applicant, they're allowed a chance to rebut, since Mr. Lemming very pointed out that he's not really an applicant. Mr. Harvey, is there any protocol at this point?
Mr. Chairman, I guess it'd be up to your pleasure whether you want to call people forward for additional discussion or testimony.
Is there will in the committee? All right. Mr. Lemming, do you have anything you wish to comment upon?
Well, thank you for your courtesy, since there's a little ambiguity as to what I am tonight. If I lived on Derrick Lane and had been through something like this, it wouldn't have gone on for 3 years. So I don't blame these people for being upset. I do want to clarify a couple of things. Number one, the last comment, you all may be aware, most of the original SUPs contained that language about their being assigned to a particular owner. As a matter of law, SUPs run with the land like a zoning does. So that has long since been settled law. I also would like to point out, somebody said Mr. Attai waited until September 12th to terminate the lease. Well, number one, he only found out about the whole thing on September the 1st. The other is that he had to wait for his attorney to write a letter. So I can take some credit for a couple of days later. But he moved very quickly, I think the point is. Something occurred to me, and you sort of put a hole in it, Mr. Cohen, but if I were the applicant, and if we were here in that status, this is a special use permit. I think we all would agree that there would not be conditions like these running with a conditional use permit today. Now, that's not technically what we're here about, but Mr. Prosser just indicated to me that they've already made arrangements that there will be no trucks coming to the property, period, that they will be unloaded if they come at all at another location. Otherwise, cars are driven there individually. Now, if I were an applicant and I were before you on an SUP or a CUP, you would have the ability to impose conditions. Now, I think that's probably beyond the scope of what the Board of Supervisors has passed along to you to do. That's pretty specific, and I know you are generally very careful about adhering to the specific resolution that comes with the referral to the Planning Commission. But if there were a way to put something like that into the SUP, I don't think the owner would have any problem at all with a condition about trucks. The The intersection is a terrible intersection. Some of you may recall that I did the zonings for both of the hotels that are there. And at one point, we actually did look at coming to a T between a couple of those properties and cutting off Derrick Lane altogether so that there would be a nice, clean intersection there. Couldn't get all of the right-of-way that was necessary for that. But obviously, that would be an ideal situation, and it may be that at some point in the future, there would be an interest in that. Mr. Attai and his property would be very instrumental in trying to get something like that worked out. But it is a terrible intersection. So I sympathize with the neighbors, and the only thing that I can tell you here on Mr. David Attai's behalf are to repeat to you his assurances to me that if he had known about this, it wouldn't have happened, and that it's not going to happen again. Now, the county can very easily monitor that and be sure that that doesn't happen again, and I'm sure that the residents of Derrick Lane will let you know and let Ms. Blackburn know if it does happen again, and if anything like this does happen again, you know, I'm sure that the county next time around will get the notices right.
Okay. Did you want to ask a question? Okay. Since there are no questions, thank you, Mr. Lemming.
Yes, sir.
Mr. Harvey and Ms. McClendon, just for the sake of the people who have raised issues, one issue was about whether or not the SUP is transferable, and if somebody could address that from our side of the dais.
Chairman Cohen, I am in agreement with what Mr. Lemming stated. That is a correct statement of the law.
Okay. And then one of the ladies who spoke raised a good question of what's the process if there's a violation in the future. So I'm not sure if that's Ms. Blackburn, Mr. Harvey, or Ms. McClendon wants to sort of educate what the process would be going forward.
Mr. Chairman, right now this has been requested for a public hearing by the Board of Supervisors. So after the Planning Commission conducts its public hearing, makes a recommendation, the board will consider the option whether or not to revoke the permit based on a public hearing. If the permit's not revoked, there could be a condition approved by the board that there be a time limit for reconsideration of revocation. Elsewise, we would be back again with a situation where if there's a violation, we could take it to the Planning Commission and board for further hearings.
Okay. So if I understood you correctly, that if there was a certain time set, then if there was any violation, it would not start this whole long process over again. It would be an expedited process.
Could possibly be, yes.
Okay.
Mr. Chairman.
Yes, Mr. Rhodes.
Just to reinforce and clarify, though, the SUP and violations of the SUP belongs to goes with the property, and therefore it stays with the property owner. It's a matter of fact, it's a matter of record, it's been identified, and now whether there was an error earlier, the fact is it's now been identified of the concern and the issue to the property owner, so there's no way to dispute that fact, and that property owner carries that forward from that point. So the allowance or the ability, whether they keep solid awareness, whether they're operating themselves, any other subsequent violations, is still to that property owner who has now been alerted to the fact of these past violations of the SUP. It's not like they're all erased or the fact goes away in any way.
All right. Okay, so Ms. Bailey, this is in your district. Do you have anything you wish to do?
Yeah, Mr. Cohen, I just want to make sure that what are my thoughts on this? It's a pretty tricky situation here, and I feel really bad for all the parties involved. But if I understand correctly, I believe that one of the options that I would have to make a recommendation for would be for this to go back to the Board of Supervisors for a period of time as unfinished business. Is that correct?
I believe that is true, right,
Is
Mr.
that
Harvey?
an option?
Mr. Chairman, Ms. Bailey, your recommendation could be that the Board of Supervisors delay a decision for a period of time to show good faith compliance. It'd be up to the board whether they want to, after they hold the hearing, hold something in abeyance as unfinished business or how they want to posture it.
So rather than having to vote tonight? then we could delay and send it back.
Well, the commission, you have generally 100 days on zoning matters once they come before you to make a decision. If the commission doesn't make a decision within that time period, then the state law says that it's a recommendation of approval.
But if we want anything to leave here, it's going to have to be voted on.
Right.
Just be voted
So-
on whatever we frame a recommendation.
Right. So, okay, go ahead, Ms. Bailey. So the options would be that we could make a recommendation to the supervisors that they sort of leave this open to see if there is good faith on the part of the landowner. And I'm sure if I understand this correctly, that if there is any violation during that time period, then it automatically moves forward. It does not need to go through the whole process all over again, right, Mr. Harvey?
Yes, Mr. Chairman, there was a similar situation with a car dealership on Route 17, where the board had their public hearing to potentially revoke the permit, and they deferred action with the caveat that it'd be revisited within a certain period of time. If there are no violations within that period of time, then the board would move on. If there were a violation, then it'd come back up for potential revocation as unfinished business.
Okay. So one option would be to do that. One option is to go for revocation, and then the other could be to defer it, and we address it again another time. I believe I closed the public hearing, but Mr. Appicello is telling me I don't talk loud enough, so now I talk loud enough and say the public hearing has ended. So now, Ms. Bailey?
Okay. Yes, I'm going to make a motion in regards to the revocation of the special use permit for SUP, and I better put my glasses on for this. SUP 80-11. I'd like to leave this open as unfinished business for a period of up to 6 months.
Okay, so
That's my
your
motion.
recommendation is for the Board of Supervisors?
No, I think it would be forwarding it to the Board of Supervisors with the recommendation that they leave it open.
Yes.
Okay.
As unfinished business.
As unfinished
As
business.
unfinished
Thank
business.
you.
To
for the
provide
help.
sufficient time to determine whether the applicant is in good faith adhering to the county's requirements.
Okay, do you agree with that, Ms. Bailey?
Yes, absolutely.
Okay, so I'm assuming Mr. Appicello, you're seconding her motion?
Sure.
Okay, everybody understand what she's saying? Do we need to have her repeat it? Stacy, are you okay? Okay, repeat it?
One more time.
All right, go ahead.
Okay, so I'm going to recommend that this be held open for a period of 6 months. It be sent back to the Board of Supervisors so it can be monitored and, look at it at that time.
For,
I think it's, your recommendation is to the Board of Supervisors
Yes.
to hold this matter open for 6 months to determine and make sure that the applicant is acting in good faith to adhere to county requirements, and if not, if there is a violation, that the county take appropriate action at that point in time.
Yes, absolutely.
Okay.
I thought I said that,
Got
but
that?
that's okay.
okay. All right, Ms. Bailey, do you want to say anything else?
No, I just think that it's, I completely understand the residents on Derrick Lane and their frustrations over this period of time. But it also comes to me that Mr. Atay has owned the property since 2001. And it hasn't been until about the last, I believe 2001, that may not be the right date.
Right.
But it hasn't been until the last 17 months that you've had real issues with the current tenant. Now, it's speculative. I don't know what Mr. Atay knew, or, what he knows or what he doesn't know. I can't prove one way or the other, but he has, once he did find out about the issue, he did come forward and he has taken action on that. So I do hope that this gives the owner of the property an opportunity to make amends with the property owners on Derrick Lane and to operate the business the way that it's supposed to be operated, so that they can both live there together, happily. Thank you.
All right, Mr. Appicello?
Mr. Chairman?
Mr. Rhodes?
I would just share that, Mr. Chairman, thank you for the opportunity. I would just share that as this goes forward to the Board of Supervisors, and if and as Mr. Attai were there, if I were he, similar to the commitment was made by the representative tonight about no trailers or anything on the property, if I were he, I would be making any and all commitments there for the public record to the Board of Supervisors, whether he wants to Again, I don't think we can open up the SUP or the conditions there, but I'd be making them as formally as I could to those commitments, to the issues that are with the neighbors. I want to believe that everything that's been represented here about Mr. Atai is absolutely true, and he is committed to doing this in a good manner. It appears that he has operated there before in a period of time where there weren't issues. But I think I would strongly suggest that if he's here, if it were me, I'd be making those commitments. I'd be making commitments to always have a couple of parking spaces for customers on the lot, so we could commit to not having any customer ever parking off the lot, even in any other form. I know it's a small, awkward lot, but I'd just be making those types of commitments to the records of the major issues that were represented here today. I'd strongly suggest that. Thank you, Mr. Chairman.
Anyone else?
I'd
Ms.
like
Fanucci?
to make a couple of comments. I am very strongly inclined to actually vote to revoke the permit. I think that you guys have shown blatant disregard and abuse to the property and to the neighbors, and I feel for them very, very strongly. And it's really, really unfortunate that because of a technicality on the owner of the land and how the notices went out, kind of gives you guys a loophole. And because of that, I can't vote to revoke it because I don't think I have the foundation to be able to do that at this very moment. However, with this open process that the board is going to hopefully keep this open for the next 6 months, please be a good neighbor. Talk to them. Find out what is their major concerns. Don't block the road. Be a good neighbor. Let them be on your side. I've said this in many, many public hearings. Having good neighbors and being a good neighbor can come back to your benefit more times than not. So I can't stress that enough. And again, I wish I could vote to revoke it, because if this is a case that I've ever seen it, this would certainly substantiate it. And I'm very, very sorry, and it's very unfortunate that the notices were messed up.
Anything? Okay. It was said earlier this evening that this is, I think it was, I don't think they used the word repugnant, but it's revulsive, the way that the residents have been treated with this. There has been a pattern, and I know this has been an absentee landlord or an absentee owner, and I quite honestly don't know that this will change. The open-endedness is nice because it seems to be a pattern of do something wrong, get caught, move the cars for a couple days, move them back. And so I'm not even sure that just, they moved everything supposedly on September 14th. That's not even 30 days from the last time they put cars there. So I really don't feel comfortable with that, because they had a pattern of moving cars back and forth. I asked about the fence because I just thought it was ironic that supposedly they didn't have any wherewithal about this other property, and then all of a sudden this fence pops up, and as soon as the county does inform them, they miraculously gets taken down, which, Aristotelian logic would say that they have to have known how it got up there in the first place. And so, again, I don't feel very comfortable about that. I don't know that there's necessarily any guarantee that they're not going to, after September 30th, change and get a new lease for somebody else. Hopefully this 30-day, this 6 months will address that, but there's no guarantee that they're not going to do that with this. I would say to the neighbors that if this goes to the supervisors with the 6-month guarantee, have your cameras ready, date stamp them, because of your vigilance. And I was brought into this a year ago and started getting emails on this, and it's your work that helped move this. And I understand how with the item on 17, the attitude was let's give them time to adjust and fix it. But now that has meant that you've suffered with over 17 months or more of a really egregious behavior. And I also, just from a logical standpoint, if the owner is in Northern Virginia and all his other dealerships are in Northern Virginia, and he's going to bring cars down to Stafford, they likely are going to have to be riding on some type of vehicle, or they're going to be adding 50 miles of mileage to these leased cars, which will diminish the value, so therefore it'll be worth less. So logic would mean that they'd have to put it on some type of trailer and unload it somewhere so they could drive it individually. So I do hope that staff will do a great job in fixing and tightening the process, so that perhaps whenever there is any type of violation, it goes to the landowner, the tenant, and their second cousin on their mother's side if it needs to. Because this is just, I just think this is just egregious for these poor people who live on the street. I think there's 14 homes that have had to suffer with this. So I'm going to vote no, because I think, I understand all the reasons why we can't revoke, but I think Mr. Atai needs to know that the people in Stafford are not pleased with it. I gave a long, I think Mr. English said I lectured, and I think Mr. Boswell said I was acting like a teacher 2 weeks ago to somebody who came forward with something that there was an issue about being a good neighbor too. So I'm being consistent. It's on you to demonstrate that you're going to make these people happy. And showing up the Sunday before our public hearing, or a day before the public hearing, to talk to a couple people, that, since you knew September 14th, I would have thought that somebody would have been there September 15th, 16th, or something, as a sign of good faith. So I will respectfully not agree with this, but only because I don't think the evidence, I think the evidence really shows a pattern of behavior. And I know this is sort of that example of that elephant where 5 people are touching it and one person feels a rope and one person feels this. But if you look at the elephant in the room, it's a pattern of violation. So, all right, we'll now take a motion. They have the motion to vote for sending this up to the board. Come on. There we go. All right, Ms. Vanucci?
I pushed it.
She's pushing. All right, and this passes by 4-2 with Mr. Boswell recusing himself. And so now it goes back up to the Board of Supervisors. Thank you for everyone for coming out this evening. Thank you. All right, Mr. Harvey, we now go to new business. And we welcome back Mr. Boswell.
Thank you, Mr. Chairman. Ms. Blackburn will lead the discussion regarding the issue of e-commerce.
Mr. Chairman, Planning Commissioners, let's see here. This is to make recommendations for proposed ordinance 17-30. And this is an ordinance that will create a definition for e-commerce and clarify its use in the zoning ordinance. Currently, the zoning ordinance defines 3 different types of occupations and/or businesses that can be operated out of a residential dwelling, including the definition of retail sale, which is at the end of these other definitions. And they are as follows: a home occupation, and I will paraphrase it because it gets a little long. It's an occupation, profession, business, or trade, with the exception of retail sales, carried on by the occupant of a dwelling unit as a secondary use. And it goes on to state that it cannot generate increased vehicle trips. You have a total percentage of the square footage of your house that you can use for such a use. There will be no outdoor storage or goods or merchandise. There will be no employees other than family members, and there will be no substantial increase in vehicular trips, of course, for the home occupation. Then we have a home business, and that is an occupation, profession, business, or trade, with the exception of retail sales. And it goes on to say carried on by the occupant as a secondary use. This one allows you to have no more than 1 employee outside of the family. You can actually have customer visits to your home. It must provide off-street parking for employee and customers. And you also have a percentage of square footage that you're allowed to use out of your house. In both instances, it's 25%. Then we have a home business, rural, and this is a non-agricultural business intended for general office, professional office, personal service, contracting, and construction. And that has a whole list of outdoor storage is permitted. You can have a sign. You have to have a minimum of 3 acres of land. The area within the dwelling cannot exceed, again, 25%, but you can actually have up to 4,000 square feet of structure that you can use for your business. And then we have the retail sale, and this is to sell in small quantities directly to customers for their own use. Well, requests for businesses out of a dwelling have increased over the years and have become more involved. In particularly, the request to sell and/or conduct firearm transfers from a residence has created questions. And to obtain a federal firearms transfer from the United States Bureau of Alcohol, Tobacco, and Firearms, the ATF, one must have a physical location for the business that is open for inspection 24 hours a day, and the transfer of the firearm must be an in-person transfer. It has been the practice that the home business, which allows for customers to come to their home, is the appropriate classification for such a business, except for the exclusion of retail sales. And this is where the internet plays a role. The internet allows for the electronic sale of the item, the exchange of monies to occur, which is not a direct exchange with the customer. This practice removes the sale directly to a customer and does not constitute a retail sale according to the definition. And this has been a discussion to some great extent amongst the Board of Zoning Appeals members. If the property is zoned A2, rural residential, R1, suburban residential, R2, urban residential, medium density, the home business requires approval of a special exception by the Board of Zoning Appeals. And the Board of Zoning Appeals has seen many special exceptions for firearm transfers. And the staff has researched the past ordinances for any discussion of what has considered a retail sale, the actual exchange of money, the type of merchandise being exchanged, and whether the exchange of money was secondary. And we have not been able to find any information discussing this topic. They do talk about retail shops, and that really had nothing to do so much with the retail sales in a home. The square footage for such, staff has researched neighboring jurisdictions to learn how home occupations are regulated and found the majority of the county allows for customer traffic to the home for such uses as professional offices, which we do, including physicians, attorneys, engineers, realtors, and similar uses with the stipulations that all customers are by appointment only. The square footage for such uses is limited, and whether an employee outside of the family is permitted or not varies. And all of that information is in your packet. As far as retail sales is addressed, Fauquier County provides for sales of firearms from the home with standard conditions. It is a by right use. Chesterfield allows for up to 2 clients on the premises at a time and does include firearm sales from the residence. Hanover County allows retail sales only by special exception. Henrico County and James City County are silent on retail sales, therefore they are not permitted. And King George County provides for an art studio, is how they allow people to come to their home. And each county addresses the subject differently, with regulations reflective of the practices and needs of the citizens of their jurisdiction. And this exemplifies how unique this subject has become. And proposed ordinance 01730 provides for a definition of e-commerce as follows. Activities that relate to the buying and selling of goods, merchandise, and services over the internet using the electronic transfer of money. Goods and merchandise may be shipped from the seller to the purchaser or transferred in person. And the ordinance further specifies that e-commerce be permitted in a home business except for the transfer of firearms. This would be no restriction on e-commerce uses in the rural home business, which is what we allow people to come and go all the time. And this ordinance was reviewed by the Community and Economic Development Committee on July 5th of 2017 and forwarded to the full board for consideration. And Resolution R-17-2010 referred this proposed ordinance to the Planning Commission and was approved by the board on August 15th. And the Planning Commission can make necessary changes to the ordinance in advance of scheduling a public hearing, and the deadline for action is November 23rd. And I have put at your, let's see if I can find it all, spot, some questions and a chart that was requested. Let's see. And this is showing, in particular, the different zoning districts and where home occupations are allowed and where home businesses are allowed and where rural home businesses are allowed. And the question started out that it appears to me that the primary purpose for regulating home businesses is to determine compatibility with the surrounding neighborhood and identify address impacts of specific businesses. And yes, this is true. And it states a home business use requires a special exception. And because it has been determined that such a use in residential zoning districts needs to be reviewed for its compatibility to the surrounding neighborhoods and the impacts of the business. So that is something, and the BZA has been given that authority by the Board of Supervisors. And these questions were given to me by Mr. Apicella, and would he like to continue on?
I have some concerns. I think this was driven in part because the BZA has had several FFL transfer requests in front of us. And so the volume of, and what usually happens when you have several repeated requests going in front of the BZA, you start to wonder whether you need to make an ordinance change. There's a little kind of a complication, and I'm not sure if folks understand what an FFL transfer is, but basically, and help me if I'm not capturing this the right way, you have a person who's licensed by the ATF to conduct a transfer. Essentially, they get a gun for a customer, and they transfer that gun to the person who basically buys the gun. And they usually do that transaction online. However, the ATF rules require that a person who is a transferor have a location that can be inspected at any point during a 24-hour period, which brings into play typically a person's house, because even a business doesn't normally operate 24 hours a day. So that's what kind of pushes us into the home business or rural home business ordinance issues, because the customer typically has to meet at I'll call them a vendor's house or the transferor's house. Even if they don't pick up the gun there, they still have to, do that transaction at the house in terms of.
Point of clarification, I'm pretty sure they have to pick up the gun at the location that the transfer is done.
No, they don't. They can actually, they could go off-site. I think they can mail the gun, but the actual transfer, and I'm not sure if it involves a piece of paper.
Yeah, because you have to call the state police and do the background check.
Yeah, they do the background check. That's part of the process that the transferor has to do. Regardless, so I don't want to get too much into the details of how that process works. All I'm trying to say is it brings a transferor's home into play because of ATF's requirements. And we were trying to find a way to basically have fewer requests going to the BZA when there's just a service being provided and it's required by the ATF that the home have to be utilized. So that's kind of a quirk. I think the transferor would probably prefer not to have to do these transactions outside of their house. Again, normally what happens is the money gets exchanged online. It's an online transaction, which kind of brings into play the e-commerce piece of this. I guess in trying to resolve the FFL issue, and what also complicates it is when we have someone who wants to do a transfer but also wants to sell merchandise, which then brings into potentially a retail sale if they're actually exchanging money at the door. However, if they exchange money online, the customer can still pick up the product at the person's house, and it's not necessarily considered a retail transaction based on our ordinances. So that's a complicating factor. Bottom line, you can't do retail sales outside of your house in any zoning category, residential zoning category in Stafford, Virginia, and I agree that makes sense. The problem, in my view, in creating this e-commerce definition and how it applies in each one of these other categories, home occupation, home business, and rural home business, is it could capture a lot of people who aren't actually doing something at their house other than conducting a transaction on their computer. If they don't have somebody visiting their house and they don't have storage of product at their house and they don't have people visiting their house, Why do we, and regardless of what house they're in, because part of the definition I think of a home business is it can only be done in a single-family detached home.
Correct.
Which I think really is. So if I have an apartment, I can't conduct e-commerce under the way the definition has been developed. So I think we have to think long and hard about, number one, who we're really trying to capture, what issues are we trying to deal with, and how is the best way to solve those issues. And I'm not sure we're there yet. I got to say, when I look at the definition of a home business, the performance standard under 6, I'm not sure what it says. I'm getting lost at the tail end of it. E-commerce with the exception of firearm transfers, only business license issued by the, ATF, and retail sales are not permitted. I don't understand how that string of words fits together. I'm not quite sure whether you can or you can't do e-commerce. And then when I look at the chart under each one of these zoning categories, number one, it's not a home, the home occupation doesn't come into play at all under any of these residential categories, and it says e-commerce with restrictions. Well, what restrictions are we talking about?
Now, if I understand correctly, Mr. Harvey, even if we were to call for a public hearing on the language that's in front of us, even if we did it on our first meeting in October, the supervisors will not get it until after the first of the year, correct?
Mr. Chairman, that's correct. There's not enough time to advertise.
Okay, so it doesn't seem as though we need to act this evening on it. If Mr. Apicello would like to work with Ms. Blackburn and others who have certain languages. I'm sort of curious, under this definition, if I were on 30-1 property, could I sell cars off of that lot?
No, you could
Okay,
not.
I just wanted to see if that was, I could sell guns though. So if, I would say
Well,
that.
I just
we
need to
work on-
understand if folks philosophically agree or disagree with me. I think, again, the reason why we regulate businesses that occur in homes is to mitigate the impacts of those businesses. So if you're just doing a transaction that doesn't have those other things happening, visits, storage, customers visiting house, why do we care? Can we create a carve-out for that kind of scenario? So I guess I need some feedback from you all to understand where you think this needs to go.
Ms. Finucci.
I agree with you specifically around FFL licenses and transfers, because I'm pretty sure that the transfer has to be done at the business of record that the FFL license was secured. So it would require, if you're the FFL holder and I'm buying a gun from you, the gun gets shipped to your home or your place of business that's on record where you've secured the FFL license. I have to go there, pay for it, either there or I would have had to give you money ahead of time, which most people pretty much take the money and hand it over at the time of sale. Then they call the state police, they make sure you're good to go, and then they transfer the weapon over to you at that time. Well,
Yeah. Yeah. Yeah.
but, yeah, but I think there should be a carve-out for that.
It's not happening at the residence. Again, the way that we've interpreted it and tried to work through this knothole is to ensure that the transaction, the monetary transaction, does not occur at the house. Even when they sell,
I don't know that you
even when
can
they
do
sell
that.
merchandise, we won't let them sell merchandise. We don't want to let money exchange hands physically. They have to do it online.
If I understand Ms. Finucci, they have to go to that residence to pick up that weapon.
They do, or
I
the home
think they can
business,
ship it.
wherever it. No, well, they could ship it, but they have to do it to another FFL dealer because the handoff has to be done from the dealer or a gun show. I just confirmed, 100% sure. And so and most of the time, it's done and they pay there. So I mean, I am not necessarily supportive of now, basically, if you look at the Stafford FFL dealer license list, they're all residences that are listed there. So then we're impacting all of these FFL dealers that can no longer transfer weapons to people. And they have it at their home because that's the easiest place to get the license. Because you have to store the weapons there. So let's say that I get a gun, or you're the FFL dealer, and you buy it off of some website, and then you have to store it till I can pick it up. it can't just sit somewhere at a P.O. box. Like, it has to be shipped to the FFL dealer. They have to sign for it. It's highly regulated. And then they have to store it until the person who's purchasing it comes and picks it up. Or they transfer it out to another FFL dealer.
Okay, so what
I
I'm
get-
seeing is there needs to be more work as to what types we're dealing with, what we really want. There has to be more nuances, whether we're dealing with just these type of items or it's everything. I also am curious if we've checked with economic development to see if there's certain trends that they're seeing that are coming up that are more they're coming down the pike that maybe we should think ahead when we're starting to look at the e-commerce, because I know that's shifting even as we're sitting
Exactly.
here. So
Exactly.
I think that we need to send it back. And I think you get the feel that there's apprehension about the different zonings and different wordings, and we need to make it mesh between the various boards, but I don't think we're there yet, so.
And I just have, if you'll indulge me for 2 seconds, I have 2 other questions. Like, how would this impact like the LuLaRoe businesses or the at-home e-commerce and how they're doing? Because I know I've bought those leggings and I've gone to people's houses when they have their open shows and you go and purchase it. So are we basically telling all the LuLaRoe leggings in Stafford County that they have to shut down? And, you know, the fact that they can only occupy 25% of their home, even though some of those homes.
Those are the existing rules.
Yeah.
I think you may need to recuse yourself.
That I bought leggings. No. And then my other question is, the classification of home business, how does that equate to farms? Because a farm can be a home business. And so have we looked at how that would kind of play in? Like, I know where I used to board my horse in Stafford County, they had a farm. They had a farm name. Would they now have to go to get a special or, a special exception in order to have that boarding farm?
Normally, agricultural uses are something totally different.
Okay.
And
It's a
if you
horse with a
are a
different
working
color.
farm, you fall under many different regulations.
Yeah.
But this is, as I said, this is something that is changing, like the LuLaRoe leggings, and people buying and selling more things off of eBay and Pinterest and these kind of
Yeah.
things. And I think this was to open up a discussion, which it appears to have done, which is wonderful. And so that we can fashion something to make it clearer as to how either these people get to operate out of their homes, they don't get to operate out of their homes, whichever. And I will touch base with economic development, but just in my own personal knowledge, like the LuLaRoe leggings and all of this, the people are selling things out of their homes. And they're doing transactions over the internet, and so there's some real things to talk about, though, as far as storage. Do we want a garage to be full of merchandise? And then what do your business owners tell you? That they have gone through the rezoning process, they have had to put sprinklers in their building, and why are you letting them do all of this without the regulations? It is really something to discuss.
Okay.
So,
And I think the problem is, and I appreciate Susan's research, not a lot of jurisdictions have really delved into the e-commerce, so there's nothing
No.
for us to kind of grapple onto and say,
Yeah.
"Hey, that makes a lot of sense," or "That doesn't make sense."
Well,
Again, I just want to end with this. My concern is touching a lot of people, far more so than we may need to with these changes.
oh, that's,
Right.
yes.
Well, I guess then we have 2 options. I think the idea of any type of public hearing next time is out. So we either have staff take the ball and we send our thoughts, ideas,
That's
questions to her, or we have a committee to do it. I would think I think it'd be far more time efficient, considering we already have so many subcommittees, that we send things to her. Do you want to say you bring it back to us October 25th or the 11th, or which is better for you, or Mr. Harvey? We hadn't heard from you in a while. I didn't want you to get bored.
Mr. Chairman, we can come back at whatever meeting the commission would like.
We don't have a lot of time, unfortunately. I think we should kind of do this piecemeal. Let's see what she can come up with by the next meeting, and then see if it continues to need to be worked, because I think we need to get it right.
Is this under a time constraint?
Yes, Mr. Chairman, since this is a specific ordinance amendment, there'd be 100 days.
Okay, so on the 11th. So I would request that members who have any ideas, thoughts, leggings, that they would send them to Ms. Blackburn post haste so that she can work up something and bring it back on the 11th.
That would be wonderful.
All right? Okay? Mr. Harvey, then we
Now, is
move
this-
on?
Wait, this is the 11th of November?
Of October.
Of October, okay.
Yeah.
Okay.
Don't push the year over yet. Yeah. Mr. Harvey, now we move on to the hospital
Definition of a
ordinance.
hospital. Yes, Mr. Chairman, Ms. Blackburn will continue to lead this discussion.
It's your lucky night.
Mr. Chairman, Planning Commissioners, this is proposed ordinance 017-32, and it is to modify the definition of a hospital to include all departments required to be included in a license of a hospital, such as a freestanding emergency department. An application for construction of a freestanding emergency department was submitted to the county, and the specific use is not listed in the zoning ordinance, and the applicant requested the use be considered a medical clinic. After reviewing the similar uses listed in the zoning ordinances and researching how the facility would operate and be licensed, a determination was made that the facility falls under the definition of hospital, since the Virginia Department of Health required it to be licensed under a hospital license. If the facility were to be treated as a hospital, the zoning ordinance would require approval of a conditional use permit before it could be constructed. The applicant did not agree and appealed the determination to the Board of Zoning Appeals, which is the BZA, and the BZA voted to uphold the determination of the zoning administrator on May 23rd, 2017 meeting. And the applicant has appealed that decision to the Circuit Court. So, to provide more clarity in the zoning ordinance for such uses, staff believes the definition of a hospital should be amended to expressly include all medical facilities that are required to be licensed under the umbrella of a hospital license or any other facility required to be licensed by the Virginia Department of Health. This item was presented to the Planning Commission on September 13th in the Planning Director's report. And since then, staff has received comments that the word emergency should be removed from the proposed ordinance language. As stated in the staff report, it is the intention that any department required to be included in a hospital license be treated the same. And staff has included the proposed language and change, and it is in your packet. And the referring resolution does allow the Planning Commission to recommend changes and modify the proposed ordinance. And this was heard before the Community and Economic Development Committee on July 5th of 2017 and forwarded to the full board. And on August 15th, the board approved Resolution R-17-2012, which referred the proposed ordinance 017-32 to the Planning Commission for a public hearing and recommendation.
All right, any questions for Ms. Blackburn?
Mr. Chairman, I have a recommendation.
Nope, can Mr. English ask the question
I
first?
just want, Ms. Blackburn, why did they say they wanted emergency out of it? Did they say what the reason was behind that?
Mr. Apicella may be able to add.
Because it should be any department of a hospital that is located off-site. So if you just include the word emergency, it's just what's called an FSED, a freestanding emergency department. So what if somebody had a freestanding radiological department and it's not connected to a hospital? It's kind of the same situation that happened with the issue that came before us. You got a hospital that's in Spotsylvania and somebody wants to put in a freestanding radiological department. Well, we haven't addressed it. The only thing we've excluded is an emergency department.
It would be for any department that is required to be licensed under the hospital license.
Okay.
And some things can be licensed separately, but this was just to do some more clarification.
Okay.
Makes sense.
Mr. Apicella.
Mr. Chairman, my recommendation is that we put the hospital definition as noted in attachment 3, page 1 of 1, that be the version advertised for a public hearing at the earliest allowable date.
Second.
All right, we have a motion and seconding Mr. Harvey, is the 11th, October 11th, okay? Do we have for enough? No, Ms. McClendon's shaking her head no, so it would be the 25th of October would be the earliest possible.
Earliest, yes, sir.
Okay. Thank you, Ms. McClendon. All right, so the motion is to move the new language to public hearing on October 25th. Mr. Aptel, anything? Yes, sir. Mr. English?
No.
Anyone else? Seeing none, we'll put it to a vote. And it passes unanimously. Thank you very much. All right, Planning Director's Report. Mr. Harvey?
Thank you, Mr. Chairman. Last week's Board of Supervisors meeting, the board sent 2 items down to the Planning Commission, one of which was a general request, the other which had included a specific amendment. The general request came about regarding the A1 agricultural zoning category and the listing of uses that are permitted in that zoning category. The board in its Community and Economic Development Committee heard testimony that the Board of Zoning Appeals, during one of its work sessions this year, had some commentary to a expert in the state who deals with other jurisdictions about zoning matters. And one of the questions and concerns was the A1 district and the number of uses that are permitted in that zone. That zoning category expanded its number of uses that were permitted significantly during the 1990s, and there was some concern that maybe the purpose of the agricultural zone's gotten deleted a little bit. So the board sent this to the commission to look at the uses allowed in the A1 classification and whether or not there should be any changes. So once the commission makes a recommendation, sends it back to the Board of Supervisors will consider those recommendations and determine whether an ordinance amendment public hearing process is in order.
All right, and is there a time frame?
No, sir,
All right.
since it's a general send down.
Okay.
The other item is dealing with.
Can we deal with one at a time? Is
Oh, yes,
that
sir.
acceptable?
Yes, sir.
All right, is there any discussion or thoughts as to what to do with this item? Ms. Finucci?
Maybe a subcommittee? You know, I like subcommittees.
Yes.
So.
And since there's no time frame, we'll find out during our meeting when next up when the subcommittees report. But we certainly, Mr. Harvey, is it acceptable to sort of say we like the idea of a subcommittee, but it would start up after the other ones and the sign, parking, and landscaping?
Mr. Chairman, that's at your discretion.
Okay, what is the feeling of the body? Okay, is everybody all right with that idea?
Can we get staff rolling on?
Yeah, and staff could start up on the research of it, right, Mr. Harvey?
Yes, sir.
Okay. And I sort of envision, Mr. English will correct me, but I think the landscaping one is almost ready to wrap up. I think from what I hear, the parking and drive aisles is pretty well paved over. Okay. And so quite honestly, we're talking maybe, in November, we start cranking on this one. So that gives staff sort of a ballpark that we're looking in November to look at it. Is that okay with everyone? All right. Okay.
I'm just in some direction to staff, maybe they can look at, again, comparable jurisdictions, what are they including or excluding in what are comparable agricultural districts?
Yes. And then you said there was a feeling, so you may ask the members who sent it down if they have any feeling or look at what they were talking about. That there were certain areas that maybe we were no longer looking at agriculture, we put too much in it.
Yes, Mr.
Okay.
Chairman.
All right, now, Mr. Harvey, parking.
Yes, the second item that the board sent to the Planning Commission is a draft amendment to our parking standards, specifically for manufacturing uses. The zoning ordinance currently requires 2.25 parking spaces per 1,000 square feet for manufacturing uses. We have an existing business that's located in the county would like to expand, and they've noted that that standard is extremely high compared to their actual parking usage because they operate on a shift basis. So in talking to the Planning Commission's parking subcommittee, we presented that to them, and they felt it was reasonable to consider an amendment to require parking be twice the size of the maximum shift, or twice the maximum shift size. The Board of Supervisors considered that and has referred it specifically to the commission. So staff believes that this amendment is fairly straightforward and would recommend the commission schedule a public hearing.
All right, any thoughts, ideas? Well, before we go to that, so the parking people are okay with doing a parking thing before you come forward with yours?
Is this on an expedited timeline because the manufacturer is wanting to come in, or?
Mr. Chairman, Ms. Vanucci, they've expressed a desire to move forward with their project this spring, which they really would like to take advantage of an ordinance amendment. So timing-wise, this could get to the Board of Supervisors in January or February, which could help meet their timeline.
Okay, because otherwise, if we're looking at the parking, we've got maybe another meeting or two, then we got to do the public hearing, and then, so we're maybe a month or two behind them, potentially? Stephen?
It could delay it because the commissions would, under the overall parking committee, come up with a recommended change, and then that would have to go to the Board of Supervisors for their concurrence and authorized hearings.
I just think it's hard to make a decision one way or another without seeing any language.
Right.
So I'm lost in shift. So if somebody is a manufacturer and they have 10 employees, we're saying they need 20 parking spaces?
Yes, sir.
Yeah. Might I suggest, and the parking and drive aisle subcommittee members can tell me, but your next meeting is October 2nd, which is prior to the 11th. We can't do a public hearing till the 25th. So that certainly, if you're amenable, you could talk about this in your subcommittee meeting. So we can go forward with the public hearing, we get it, on the 20th, we can advertise for the 25th. At the same time, the subcommittee can look at it, we can see the language, and if there really is something that needs to be changed, we can change it at the 25th as long as it's not more restrictive. Correct?
So what about the maximum? Let's say we have we brought in a big manufacturer and they have 300 employees. Are we really saying you need to have 600 parking spaces? I'm just trying to, look at kind of both sides of the issue. If you're small, it might not make a big deal, but if you're big, and I don't know how that compares to what's the requirement now.
Yeah, Mr. Chairman, Mr. Appicello, the issue with shift work is that when the shift changes over, you have to have parking for everyone. So that's why it's double the size of the maximum size of the shift.
That makes sense.
I'm not following you, because again, if you're a manufacturer, the way I'm hearing it, it's based on the number of employees that you have in a given shift. So and some manufacturers run 24/7, right? So if we brought in a large manufacturer and they had a big operation and they had 300 employees working, in 3 8-hour shifts, they'd have to have 600 spaces.
Yes.
Right.
And why would they need 600 spaces?
Because you gotta take care of the shift that's on that.
Right, they're leaving and the new shift
Yeah,
is
but they're
coming
not
in.
leaving
Yeah,
at
but
the
they're
same
coming,
time.
they don't stop the production.
Right.
They have to,
No, I get that, but why
Yeah.
do they need an extra 300 spaces?
So you gotta have, the first 300 are filled up. What are you gonna?
Right, but those people are leaving.
Well, not yet.
Not yet.
Okay. Is it, right.
It
Okay.
just seems potentially onerous. I just don't understand
Yep.
and we're not hearing from the business side, we're not hearing from the economic
Okay.
development folks, if this makes sense. I just think we're kind of rushing without necessarily understanding the
Okay.
issue.
Jeff, can you talk about what's our current, I don't remember, what is our current standard?
Okay.
Again, our current standard is 2.25 spaces per 1,000 square feet. And we can give you some specifics with regard to this manufacturer and what size building they're ultimately wanting to have and draw comparisons. In this particular case, the ordinance requirement that we currently have has more than double the amount of parking that they believe they need for their manufacturing business.
I just feel like here we go again. We're going to make a broad change for one individual that might have impacts on other people downstream, and we don't necessarily see what those impacts might be. It may work great for this particular manufacturer. It may actually keep another manufacturer from coming to Stafford without going back and changing the rules if, again, it's too onerous.
Okay, well, and Mr. Harvey, correct me if I'm wrong, if staff came back on the 11th with some generalized information, The earliest, we could not get, at that point, a public hearing on the 25th of October, but we could do a public hearing in November if everyone's amenable to the language of that. Since we're looking at the supervisors hoping to get this in January or February, that still gives time, even if we have a public hearing on the 15th, and then we end up carrying it over to December 13th, for it to get to the supervisors so that they could schedule it for January or February, correct?
I believe we can work into a November hearing date if we need to.
Okay. So I think I get the feeling from Mr. Apicella and I think a couple other people on this side of my ears. They would like to have some information brought back by staff on the 11th with the idea that we are aiming for ideally a November public hearing, but we have wiggle room for December if need be.
I would just also ask, Mr. Chairman, if there was anything that had been prepared for the board on the development of that recommendation, if we could get it just in its raw form for the second.
Yes, sir.
For when we meet.
For the 11th, yep.
Well, we're going to actually, the subcommittee meets, I like to actually kind of glance at it while
For
we're
the
doing that
parking,
too.
yes.
Yeah.
Right, and any information you can get to the parking subcommittee so they can give their input as well on the 11th. Okay, all right,
And Mr. Chairman, that concludes my report.
all right. Ms. McClendon?
I have no report this time, Mr. Chairman.
Okay, thank you. Committee reports, sign committee. Okay. Parking and drive aisle?
Our next meeting, which you just heard, is scheduled for October 2nd, and we're really hoping to iron out our suggestions and be able to move forward in the process to engage the public comment at this period. So, stay tuned.
All right, and the landscaping committee, Mr. English?
Our next meeting is the 25th, and hopefully we'll have everything sewed up and be able to bring back.
Right, if memory serves me, we were waiting for some information from the parking and drive aisle committee, and so that's why we were sort of waiting on them for that. So the dates and times are on our website, right, Mr. Harvey? For anybody who's
Yes, sir.
so inclined to come and watch us eat, Mr. English and I eat dinner while we have our meeting. All right, Chairman's report. The only thing I have to say is that I asked Mr. Harvey to forward to all of you. I received an invitation about the public hearing for the high-speed rail. The high-speed rail is going to be hitting, the meeting is on October 19th, which is the Wednesday between our meetings in October, so we could actually go to it at 7 p.m. at James Monroe High School. So I didn't know with all this transportation talk, people wanted to hear the latest innovation of that. And that is it. The TRC information, it has been canceled.
Mr. Chairman, I make approval for no minutes?
Yes, okay. And there, we have no minutes to do. All right, and so if there's no other new business, I will call this meeting adjourned. That was a wimpy one. There you go, that's better.